Mistake number 3 that you can make in your disability insurance claim that can kill your case. Well, one of the common mistakes I see is that the employer will say to the disabled employee, you know, you're having trouble working, I think that you should stop work and apply for your benefits. Well, just because your employer thinks that you're disabled doesn't mean that you actually meet the definition of disability under the terms of your policy or plan. Now, I've even seen cases where an employer has refused to allow the employee to return to work without approval from the doctor, and even agreed with the doctor that the employee was unable to work. But the long-term disability carrier wouldn't pay benefits. So how can this be? Well, the answer is that in most insurance policies or plans, they are ensuring your inability to do your occupation, not your job. Your occupation, as that term is defined in the policy or plan. So you need to understand there's no uniform definition of occupation. You've got to get out your policy or plan and read it to see how it's defined. Is it defined as how your occupation is performed in the national economy, how your occupation is performed in the local economy, how your occupation is performed for your employer? You need to understand that definition, because even though your employer says you can't do the material and substantial duties of your occupation, the disability carrier might disagree with them. And that's particularly true if, in fact, the doctor does not necessarily understand the definition of occupation and fills out the attending physician statement form in a way that allows the disability carrier to say, hey, based on your doctor's restrictions and limitations, we think you can do your occupation and we don't really care what your employer has to say. Let me give you an example. My law firm represented a beer route driver who sustained a brain injury and had brain surgery. He could not deliver the merchandise because he couldn't remember the route he had run for years. So they put him inside the beer distributorship and they let him count bottles. The long-term disability carrier denied his claim in part because they maintained he was able to perform his duties either as a delivery driver, because that's what he was doing, or even his modified job. Now that's crazy. So that mistake isn't made, here are my suggestions. You need to read that policy or plan so that you understand what the legal definition of disability is, the legal definition of your occupation, and think about why it is, based on your problems, you couldn't perform the material and substantial duties of your occupation, as that term is defined by the policy, and that you're talking with your doctor about the physical and mental requirements of your occupation, so that when the doctor fills out the attending physician statement form, they understand what those duties are and they can answer the questions in a way that will help you win your disability claim. Asking your doctor just to write a note isn't going to cut it. Got it? Now, you need to understand that there are even more mistakes. So mistake number 4 is not understanding that disability policy or plan before you stop work. If you have any questions, give us a ring, 727-894-3188 for a complimentary consultation.